And we are live. My name is Abe Mashni, criminal defense attorney here in Lexington, Kentucky. And today we're going to be talking about changing bond conditions in Kentucky. And what I mean by that is you have an active case, you've been arrested, and you've posted bond, meaning you've been released from jail. The judge has issued some conditions for you. Some of those are standard, some of those are specific to your individual case. Some standard conditions are always going to be make all court appearances and no new offenses. And so, but there could be some special considerations, like you can't go to a certain store if it's a theft case, or you can't have contact with a victim if it's a domestic violence or assault case, or it may be that if it's a drug case, you have to do drug testing, or some may even say you have to go to substance abuse treatment while the case is pending. And so let's say a judge has ordered a special condition like that and you're unhappy with it. With COVID these days, cases are dragging out for a long time. And so what may be in the past a 6-month case is now going well into a year. And so you want to change one of your bond conditions. What are your options? So I think you have two options. One's an easy way and one's a hard way. Let's talk about the easy way first. The first way is going to be an agreed order. You're going to need to talk to your attorney about what condition you want changed. You're going to need to discuss the realistic probability of that actually happening. And then assuming that your attorney thinks that it can happen, go forward. Talk to the prosecutor about it. Make the request. If they agree to it, then it can be done by an agreed order. Your attorney just drafts up a document, explains what the condition change is going to be. You sign it. The prosecutor signs it, and the judge signs it, and then from that point, as soon as the judge signs it, you're good. That condition is changed, and it's just as if you went to court. The second option is usually implemented if the prosecutor does not agree to the change, and that's going to require your attorney filing a motion to get onto the docket and make that request. And so there's a couple considerations to think about if you want to go that route. First and foremost, if it's an assault domestic violence case where there's no contact with the victim, you're going to want the victim there. The judge is not going to change the contact condition if the victim is not there or if the victim does not want that condition to be changed. And so you can't have contact with them, but your attorney can, and so they need to be in contact. The second one is going to be for drug cases. If you've been drug testing for over a year and all of your tests are clean, you may want to ask that condition of drug testing be lifted and show the judge and bring documentation of all the clean drug screens or all the substance abuse treatment you've done in the past. Another option would be if you are on home incarceration and you want the ability to work. It may be a good idea to bring proof that you have a job waiting for you. It could just be as simple as a letter saying he can start working here. And so I hope that you learned a little bit today. I hope that you enjoyed the video, and thank you so much for watching. If you have any questions whatsoever about bond conditions here in Kentucky, please give us a call, 859-259-0727. Thanks.